December 20, 1952. A cold Saturday evening in McKinney, Virginia. It's a quiet crossroads in Dinwiddie County, lit up for the holidays. Down the road, A.H. Zehmer is running his combined restaurant, filling station, and motor court. Around 8 p.m., W.O. Lucy walks through the door. He's a local lumberman and farmer, carrying a partly filled bottle of whiskey, looking to have a drink with Zehmer and talk some business. The two men sit at the diner counter. Over the next 40 minutes, they share a few drinks and argue over a piece of local property. When Lucy finally walks out into the cold air, he has a piece of paper in his pocket. If that paper is valid, he has just purchased the 471.6-acre Ferguson farm for $50,000. Did a life-changing transfer of land really just happen over a bottle of whiskey? Or is that scrap of paper completely meaningless? The very next morning, Zehmer insists the whole thing is a joke. He claims they were two drunks bluffing to see who could talk the biggest, and the liquor was doing the negotiating. Lucy doesn't see the humor in it. He takes the matter to the Circuit Court of Dinwiddie County, where Judge J.G. Jefferson Jr. presides, and files a specific kind of lawsuit. He files a bill in equity, which is a legal petition asking a judge to compel a specific action or fairness remedy, rather than just awarding money damages. Judge Jefferson reviews the diner dispute and dismisses Lucy's bill, concluding that a drunken joke over a restaurant counter shouldn't cost a man his farm. Lucy refuses to let the case end there. He takes his appeal to the highest judicial body in the state, the Supreme Court of Appeals of Virginia. He asks the appellate justices to grant specific performance, a court order that forces a party to follow through and execute a contract exactly as written. The appellate panel now has to make a definitive call. Will they forcibly transfer a man's real estate based entirely on a handwritten paper trail left behind on a Saturday night? On November 22, 1954, Justice Archibald C. Buchanan and a unanimous panel of 4 other justices sift through the trial record. They examine Zehmer's first line of defense, his claim that he was high as a Georgia pine and lacked legal capacity. Capacity is the legal ability and mental competence required to understand the nature and consequences of making an agreement. Yet the court record tells a different story. Under oath, Zehmer recounts the night in vivid chronological detail, and his own wife testifies that when Lucy left the diner, she suggested Zehmer drive him home, hardly the reaction to a man too drunk. The sheer sharpness of Zehmer's memory contradicts his claim of severe intoxication. The physical evidence of his coherence dismantles his defense of lacking mental capacity. With the intoxication defense failing, the court looks at Zehmer's second claim, that the writing was just a joke. But the record shows Lucy had seriously offered Zehmer $20,000 for the farm years earlier. To force Lucy to admit he didn't have the cash, Zehmer grabbed a restaurant guest check and scribbled out a contract on the back. In doing so, he satisfied the statute of frauds, a legal doctrine requiring certain agreements, particularly the sale of land, to be in writing and signed to be enforceable. The moment the ink hit the paper, the interaction moved past idle diner banter and entered formal legal territory. Lucy looked at the draft and objected. The check started with the word I, but the farm was jointly owned. He demanded Zehmer rewrite it to say we, so his wife, Ida S. Zehmer, would sign it too. During this revision process, the two men deliberately debated what was included in the sale, and Lucy requested a specific provision regarding the condition of the legal ownership documents. They agreed the title had to be satisfactory, referring to the deed or title, which is the official legal document that proves ownership of a property and transfers it from one person to another. Tearing up a first draft, correcting pronouns, and adding title contingencies are the exact outward actions of a serious business transaction. You simply do not redraft a punchline. There remains a massive disconnect between Zehmer's internal thoughts and his outward actions. He testified that before his wife signed the second draft, he whispered to her that it was a joke, purposely keeping his voice down so Lucy wouldn't hear. But after the whispering, Zehmer placed the signed paper on the counter. Lucy picked it up, folded it into his pocket, and dropped a $5 bill on the bar to bind the deal. The law requires mutual assent, which is the outward indication by all parties involved that they agree to the exact same terms. A secret whisper to a spouse does not erase 40 minutes of drafting, revising, and delivering a signed real estate contract. Zehmer's entire defense rested on an increasingly obsolete philosophy of contract law that prioritized a person's secret intentions. This was known as the meeting of the minds, a traditional and somewhat outdated concept that all parties must share a true, internal psychological understanding and agreement for a contract to be valid. Justice Buchanan uses the McKinney-Diner dispute to explicitly reject that requirement. He points out that courts cannot be expected to read minds, decipher secret jokes, or weigh unexpressed mental states. This diagram illustrates the modern standard the court applied. They ruled based on the objective versus subjective theory of contract. This principle judges agreements by the outward, reasonable meaning of actions and words, rather than secret internal thoughts. Citing the restatement of contracts, Justice Buchanan reverses the lower court's decision. He orders specific performance, forcing the Zehmers to hand over the Ferguson farm for $50,000. You can be drinking, and you can be privately joking to yourself, but if your physical actions, your written words, and your behavior manifest a clear deal to a reasonable person, that outward act is the legally operative fact.